Good afternoon. My name is Jim Bruinsma, and I'm here with my partner, Jeff Gray, for our program today on fiduciary responsibility under ERISA, guidelines for retirement plan investment committees. This is part two of our two-part series on dealing with and managing your 401k or 403b plan. The goals for today's presentation are to discuss who's a fiduciary under ERISA and their legal responsibilities, and to discuss the explosion of lawsuits against fiduciaries and the practical implications of those lawsuits. Let's first start out by talking about who is a fiduciary. And under federal law, a person's a fiduciary to the extent that they have discretionary responsibility relating to a retirement plan that's subject to ERISA. It's based on what your responsibilities are, not necessarily based upon a title. The focus today is going to be on the responsibility to choose the investment funds that are made available to the participants in your 401k or 403b plan. Under the DOL regulations, you are a fiduciary if you have discretion regarding the choice of the investment funds that are made available to participants. Now, in many contexts, employers have committees that carry out these duties. Oftentimes, the employer establishes a charter for the committee that provides guidelines for their fiduciary responsibilities. These committees often also choose other service providers for the plan, which also is a fiduciary decision. What requirements are imposed on fiduciaries? Well, the bar is high. ERISA has a series of requirements that need to be satisfied. Loyalty, to act in the best interest of participants and beneficiaries, to keep down the costs of the plan and focus on providing benefits. And look at the third one, what I call the prudent expert rule, to act in a way that protects the participants' interests, and you do so with a level of skill that you could be termed a prudent expert. I included a couple quotes from lawsuits that describe a little bit of what it means to be a fiduciary. I love the second one, where they talk about that a pure heart and an empty head are not enough. You need to be the prudent expert and act in a prudent manner. As indicated, there's been a dramatic increase in lawsuits against fiduciaries relating to 401k and 403b plans that have participant-directed investments. It focuses on the investment menu that's being made available. And what exactly do they say the fiduciaries are doing wrong? Largely, it's that the participants are ending up paying too much for the services that are being provided and the fees that are being invested in. They say the fiduciaries are basically asleep at the switch. They didn't do their due diligence. They failed to understand how costs are charged by service providers. They didn't understand the investment funds. Oftentimes, they talk about the failure of the fiduciaries to choose the investment funds that have the lowest share cost. We'll talk more about that in a minute. Also, a failure to negotiate lower record-keeping fees, either at the beginning or as the plan grows in size. In some cases, they say you provided too many options, sometimes not enough options, or you provided actively managed funds when you should have been providing index funds. There are many of these types of allegations that are made against the fiduciaries. Interestingly, look at the numbers involved here about cases that have been filed. These lawsuits probably began 10 to 15 years ago. They were started by a law firm in St. Louis, the Schlichter firm. Now there are many law firms that file these cases. You'll see that the number has been more than 150 since the start of 2020, and probably about half of them have been filed by one small law firm in Pennsylvania. And in fact, they have sued employers in West Michigan. And originally, when these lawsuits were started, the plans for which the fiduciaries were being sued often were very, very large, often with more than $1 billion in assets. But as we see more law firms, plaintiffs' law firms enter the fray, there aren't enough billion-dollar plans to go around, so now they're starting to target smaller plans. So it's not a situation where you can say, well, our plan's not $1 billion, so we're safe. The reality is today, probably no one is safe. There's also been some settlements this year. You can see the numbers, well over $1 million. Jeff, you had some specific comments about the Walgreens settlement to provide some context as to how these cases get settled and who ends up getting paid.
I did. Yeah. Thanks, Jim. I thought that case was interesting, and I just wanted to look into the numbers a little bit more. The allegations in the Walgreens case, the main allegation was that Walgreens, its fiduciaries, had kept an underperforming suite of target date funds in the lineup. I think the allegation was that the target date funds had underperformed the benchmark for a decade. And the claim was that that cost participants $300 million in damages. So Walgreens has this $300 million case that was brought against members of its board of directors, the committees, the fiduciaries, basically anyone who would have been involved in the decision regarding the investment lineup. And so they filed the lawsuit. Walgreens filed a motion to dismiss the lawsuit, basically saying, yes, the funds maybe underperformed compared to what the plaintiffs are comparing them to, but these funds were purposefully conservative and they were low cost. So we had a legitimate fiduciary reason for choosing these funds. What the judge basically said is, well, that's great. You can explain that to the jury. We can let the jury decide whether or not Walgreens met its fiduciary duty. And at that point, Walgreens then is looking at expensive litigation that could go on for years and involve depositions of very high level people. And for whatever reason that we're not privy to, decided to settle. And so it settled for $13.75 million. $4.6 million is going to the lawyers. Keep in mind that they, at this point, have only filed a lawsuit and there's been no discovery, and they've only had limited motion practice at this point. So $4.6 million to the lawyers. That leaves a little over $9 million left for the class of 195,000 participants. So split up that, even if we just take a rough number, divide 9.15 million by 195,000, it ends up about $46 per participant. So that's really I think the tragedy about this, and there needs to be something done, maybe legislatively, because the lawyers walked away with millions, the participants walked away with a few dollars, and this kind of a case, I think, puts a chilling effect on committees who maybe make a decision like Walgreens did in this case. So anyway, I just thought I'd mention that because I thought the dollars were interesting.
And we'll talk more about the practical implications of this as we go forward in our presentation. We also wanted to discuss a very important U.S. Supreme Court case that was decided earlier this year involving Northwestern University and its 403B plan. This case was filed many years ago, and throughout the entire process of the case, the plaintiffs lost. Part of the rationale why cases were dismissed is that the court looked at the fund lineup and said, well, there are many funds here, and many of them are low cost. Others are more expensive, but people had plenty of low cost options. The Supreme Court, on the other hand, said it was a breach of fiduciary duty to include any imprudent investments in the fund lineup made available to the participants. The fact that you had many prudent investments doesn't protect you. Every fund in your lineup has to be a prudent choice. As a result of this decision by the Supreme Court, the Northwestern case went back to the lower court for further proceedings. There's been no resolution of it so far. But Jeff mentioned in the Walgreens case that the normal practice when a lawsuit like this is filed is for the plaintiff or for the employer to file a motion to dismiss, stating that their plaintiffs failed to allege facts which would allow them to win. Since the Northwestern decision, basically all the motions to dismiss are now being dismissed. And the plaintiffs are getting past that stage in the process of the lawsuit. And as a result, employers are faced with the Walgreens choice. Do we continue to fight this, or do we try to settle this? And I think the plaintiffs' firms are counting on the fact that employers are going to want to settle these cases. I guess one of the things I wanted to comment on is something that comes up in most of these lawsuits, and it relates to revenue sharing. That's a term that many people may not be familiar with, but it relates to a payment by a mutual fund company to a service provider, such as a record keeper. And many service providers then use revenue sharing to offset their fees. Interesting that each mutual fund may have multiple share classes. So a specific mutual fund has different share classes with different expense ratios. The ones with higher expense ratios generate more revenue sharing. And oftentimes, particularly in the past, employers intentionally chose funds with higher revenue sharing. So any expense of administering the plan would be paid from the revenue sharing without the participants really even being aware that this was taking place. With these lawsuits, the thought about the attitude towards revenue sharing has changed. Also, it should be noticed that actively managed funds have higher expense ratios than index funds. Index funds basically have no revenue sharing. What we see today is that employers are choosing the fund class that has the lowest available revenue sharing. A further factor that we've seen change over the last period of time relates to the use of the revenue sharing. As I said, most employers now want to have funds that don't have revenue sharing or have the revenue sharing being as low as possible. But because of the fact that actively managed funds tend to have revenue sharing while index funds do not, this often resulted in a disproportionate application of those expenses to different participants, depending on whether they chose to invest in actively managed funds or in index funds. In response to that, and to create greater fairness among the participants, we now are seeing a move towards what I call fee leveling, that the revenue sharing generated from a participant's account is now being credited back to that participant's account. And instead, the expenses are not being paid out of the revenue sharing, but the expenses are being paid by all participants based on a formula chosen by the plan fiduciaries, typically either a flat dollar amount per head or in proportion to account balance. But the move towards fee leveling is an important change that has evolved out of many of these lawsuits. At this point, I'm going to turn this over to Jeff, and he's going to talk about the practical implications of these lawsuits and what it means for plan sponsors and plan committees.
Thank you, Jim. So in terms of a little background on the practical implications, if we think about how this might come up, The idea with practical implications is, okay, how do we document, how do we prove that we have met our fiduciary duties under ERISA? How do we ensure that we're actually meeting them, and how do we document that? How do we prove that? When might you need to prove that? Well, there could be a lawsuit, as Jim was describing, but there could also be a Department of Labor audit. We see these audits fairly regularly. They often are asking more questions about remittances of payroll deferrals to the record keeper, but there's also always a request for committee minutes or documents. The DOL often interviews committee members about their fiduciary practices, about whether they've had fiduciary training. So this could come up in any number of ways. And the idea here with this last section is just to give you some practical thoughts about how to proceed given these obligations and these lawsuits. So as Jim described, fiduciaries have to have this duty of prudence, the prudent expert rule. And as part of meeting that standard, fiduciaries need to engage in a careful, deliberative approach. So this is the idea of procedural prudence. It relates to the process. What is your process as a group of fiduciaries for reaching a fiduciary decision? One of the things that Jim mentioned was the charter. This process can be spelled out in a charter, for example. The charter might describe how often fiduciaries meet. So you should meet regularly. Depending on the size of the plan, it's common for a committee to meet, say, quarterly to talk about investment performance and the investment lineup. To the extent necessary, the fiduciary committee also needs to consult with experts. Most committee members are not financial experts. Even if you're a CFO or in the Treasury Department or finance, you may likely need support from outside experts regarding the types of investments that should be in your lineup. And fiduciaries should also follow an investment policy statement. That policy statement is partly self-serving. It'll have a number of sections that will acknowledge the fiduciary status of the committee members. It will outline the types of investments that are permitted. It will establish the committee's emphasis on reasonable fees, for example. But you can also add practical information in this investment policy. You may, for example, want to add provisions that explain why revenue sharing is credited back to participants the way it's credited back, the way you've decided to have that work, which Jim was describing earlier. That's something that could be in an investment policy statement. You may want the rules that you will follow regarding a watch list for funds, what you'll do when a fund underperforms for some period of time. Those are all sorts of things that you can include in an investment policy statement. As I was saying, the idea is to be able to show that you as the committee members are acting as prudent experts. So you don't have the empty head. What is that, Jim? I forgot already. Your heart's in the right place.
Yeah, your heart's in the right place.
That's not enough. Having your heart in the right place is not enough. So you've got to show that you have met your obligations as a fiduciary. So the way we typically recommend doing that is to document the steps. Document the steps that the committee undertook to reach its decision. So the way you typically do that is to have minutes in a fiduciary committee meeting. And those minutes should identify who was there, including your advisors or consultants. They should identify the issues that are discussed, identify the documents, summarize the decisions and the rationale for why those decisions were made, including the advice that the experts have provided, and then identify issues to be discussed at later meetings, including any investments that are on a watch list. Now, that's all a summary of what should be in there, but you also have to think about what shouldn't be in there, or at least to be careful and vigilant and to understand that these minutes may be discoverable. The idea with these minutes is to show that you've been meeting your fiduciary duties. So something that you would not want in the minutes, for example, would be some concern about perhaps a fund being too expensive and then it just stays in the committee minutes and it's never been acted on. I mean, it's fine to document that, but then there needs to be later minutes that show, yes, we reviewed this, we took advice from our experts, and here's how we decided to handle that fund. So issues that are flagged but then are never resolved are a typical problem that we see in these minutes when, for example, a DOL investigator asks for these minutes.
Oh, Jeff, let me ask a question about that. Would it be acceptable to choose a fund that's more expensive if you had a business reason for doing so?
It would be, right? You don't have to pick the lowest cost lowest cost record keeper or lowest cost investment provider, investment manager, or the lowest cost fund if there's a kind of legitimate reason for keeping it or for choosing it in the lineup. And I've been in committee meetings before where there's been a fund that's been selected that was more expensive, but that investment manager had a particular investment methodology that made sense to the committee members and made sense to the investment advisor.
So what they would do in that case is just explain then why that choice was made in the minutes?
Right, explain exactly why that choice was made in the minutes. Sometimes if these funds do have revenue sharing, you may have a fund that looks more expensive, but in reality, it pushes more revenue sharing back to the committee, and the committee knows that the way they allocate that back to participants ends up that fund may end up being actually less expensive to participants. So there are a lot of things to think about. And yeah, I think the key here is just to make a reasonable decision based on advice from experts and to document that.
Yeah, because isn't the bottom line is you're not expected as a committee member to have a crystal ball,
right?
Because we wouldn't need day jobs on.
Right. As much as the plaintiffs' lawyers argue that you are expected to have a crystal ball, that's not part of the law. And
process is the key.
Process is the key. So part of that process is keeping a file, a good fiduciary file that documents, includes the minutes, includes the SPD, includes plan documents.
So you would say with the minutes, they probably ought to include all the things. If you had a financial advisor there who came with a book of information about the performance of your investments, that those ought to be kept with the minutes.
Yes, they usually do come with a very big binder or a big bound copy, and you cover some of those. You only have so much time in these meetings, but yes, I'd maintain a file for each meeting with all the documents and the minutes, and we're always happy to review minutes too if you have any questions. So there's documenting the process, and then there's also just establishing the process for selecting and monitoring investments and service providers. Much of what this involves, you have to consider the fact that these often need to be negotiated, particularly arrangements with the record keeper. Your process for selecting a record keeper should include competitive bids, and also understanding the fees and the fee structure. So if your record keeper charges an asset-based fee based on the size of your plan, over time, as those assets increase, the fee to the record keeper increases. And that's really how a lot of these fee cases started, which was just that you might have a record keeper getting a asset-based fee for 20 years and it hasn't been renegotiated. And as a result, the record keeper is getting much higher fees than it started out getting, and yet its work really hasn't increased that much. So understand the fee structure, consider competitive requests for proposal as part of this process. If you've had a record keeper and it's tough because you build relationships with these people, you don't necessarily want to say, hey, we want to go out to market and see what's best. But as a fiduciary committee, you really need to do that from time to time. How often you do that just depends on the size of the plan, the risk, your experience with the record keeper.
What about the possibility of just doing benchmarking?
Yeah, I think you can benchmark record keeper fees probably without as much of a formal request for proposal process. And you can certainly do that more often, although I think it's still a good best practice to do a formal RFP from time to time,
sure,
just to document that. There's also a key to this is also regularly documenting that you're undertaking independent fee benchmarking. So this is where your investment advisor may be able to help you. There are other advisors. The idea there is to benchmark the fees that the record keeper charges and that are the investment management fees. And I think there's a lot of room for opportunity here in terms of what service providers can do, because I at this point, I think a general benchmarking of your overall fees is good to do, but it's not necessarily as specific as maybe it should be. I think it's good to be able to show that you benchmark not only the fees in total, but also that you've considered benchmarking the fees of the target date funds, for example, or if you have a actively managed small cap fund, that at some point you understand what the fees are that fund charges relative to other comparable funds. And again, I think that's something that your investment provider can help you do. And then finally, just evidence of actually negotiating the fees. When you go through this request for proposal process or an RFI, request for information, more of an informal process, keep good evidence of that, keep good documentation of what you did. Also consider fiduciary liability insurance. Many employers have this, but not all. It's not required by ERISA. It's something different than what we call the ERISA bond or honesty insurance. It's different than D&O coverage. It's coverage that's specifically intended to cover lawsuits against fiduciaries for a breach of fiduciary duty. Now because of these lawsuits, it's gotten harder to get this insurance. The underwriting scrutiny is much more difficult. I understand that at this point, insurers are now asking for this detailed evidence about the committee's process, about the committee's training, about whether the company's gotten any inquiries from this law firm that you mentioned, Jim, or other law firms, or what these firms are doing is soliciting participants through social media. I've seen one insurance application that says outright, have your participants been solicited through social media to participate in a lawsuit? So you have increased underwriting scrutiny, and you also have increased cost. We've heard of increases in the premium of 20 to 30% this year. They just keep going up and up. So, but if you have it, I think that's part of why these cases are getting settled, because these employers have insurance for this. The insurance companies also have an interest in settling. So it can be very useful when the time comes. Fiduciaries may also want to hire other fiduciaries to assist in meeting these responsibilities. These typically come in two different types. You have, and the two different types fall under two different provisions of ERISA. The first one is what we call a Section 321 fiduciary. This is a fiduciary that provides investment advice to the plan fiduciaries. And if you're providing investment advice versus just information, you're providing actual investment advice, that advisor is a 321 fiduciary. And those fiduciaries, we'll talk a little bit on the next slide here, those fiduciaries are really co-fiduciaries with the committee, because ultimately what happens is the committee still retains the decision-making power. So the committee makes the final decision. It's getting advice from this 321 fiduciary, but ultimately the funds that are in the lineup are chosen by the fiduciary committee. And so you have a co-fiduciary relationship. But the other option is a 338 investment manager. Again, that's just described in a separate section of ERISA. And in that case, the committee basically gives up the reins in terms of the decision for the investment funds. The committee turns over that choice to the investment manager. That the idea there is then that reduces the committee's potential liability, because it's no longer making the investment decisions. The 338 providers making the decisions. Of course, the committee still has a fiduciary responsibility in terms of selecting that investment manager. So everything we talked about the process and the duty of prudence, that all applies to the selection of the investment manager. And so as a result, the committee has responsibility for that and responsibility for, of course, the fees that are charged by the investment manager. So hopefully that provides some additional context and some additional practical suggestions for meeting your fiduciary duties. I do not see any open questions at this point. So thank you for joining us today. And we'll be back next month for our next employee benefits webinar. Have a good day.